Welcome to Brutal Honesty with author, teacher, and national trial lawyer, Nick Rowley.
Let's talk a little bit about the experts, defense experts compared to plaintiff experts. How did you use them either tactically, or how did this all play out for those people that haven't watched it on CVN yet?
In the liability phase, we had John Bro testify, B-R-A-U-L-T. He's a biomechanical engineer, basically, an expert who's going to come in and tell jurors how an injury happened and talk about body mechanics. And he broke down all the movements of the body and exactly what happened. And then we reenacted it in front of the jury. He's a phenomenal expert. I've known him for 15 years. I've had him testify in cases, against me. And he's a very, very conservative expert. He has integrity. And that's what I respect about him. I always want experts who have integrity. And he looked at this case and he said, you know what? Count me in. What happened to this young man is wrong. And I'm going to come in and help the jurors understand what happened. The defense expert, some Dr.
Lee Han.
Doctor, is she a doctor? No, has a master's, right?
Master's. Han Lee.
Yeah.
Han Lee.
Dr. Han Lee of MIT. Dr. Han Lee of MIT. She actually helped our case because she did an analysis and created some diagrams that the defense did not show the jury when they had her testify, showing that the cup was not seated, that it was this far out of the tray. So we used that, and Daniel Bittigary, our partner from Montana, cross-examined her and showed that this was a dangerously placed cup that wasn't secure. It was 180 degrees and it was handed over to somebody and spilled within 1.4 seconds. Her testimony hurt the defense case.
So that's liability. What do you use for experts in damages?
Dr. Erwin Goldstein, who's the best sexual medicine doctor and the most experienced and the most published in the world. He's a phenomenal expert, a phenomenal doctor, a phenomenal human being. And he came in and showed the jurors through ultrasounds and pictures and medical evidence and medical journals what exactly happened to Michael and why it is that this is a permanent injury. We also had Dr. Kevin Brenner, who's a board-certified plastic surgeon, who was also a general surgeon, who was also a burn surgeon, come in and testify about what the internal damage was and how, while the surface of an area that was burned might heal up in an area where the tissue is soft, like the penis, and that might look like, wow, that's pretty well healed. Down underneath that initial layer of skin is where the damage is. So Dr. Brenner came in and explained that and talked about the different levels of tissue and what happens with a burn like this, and explained to the jurors what allodynia is. Allodynia is where you have an abnormal pain sensation, a pain response to any type of stimulation, where, again, with Michael, what used to be pleasure is now pain.
What were the defense tactics with their experts?
They had some expert who went to medical school in Argentina. He came in and, very charming man, said, I'm a burn surgeon, tell you what the injuries are or what the injuries are not here, and it's not really that bad. And on cross-examination, I said, so you told the jury you're a burn surgeon, right? Where do you have staff privileges? He goes, well, I don't have staff privileges. And I knew the answer to that question. And you said you're a burn surgeon. Tell the jury the last time it was that you performed burn surgery or any surgery. It was 1998. So I told the jurors in closing argument, I wonder what happened back in 1998. Why isn't this guy practicing medicine? Why is 95% of his income all coming from doing these medical legal cases and working for corporations like Starbucks? Let's put it into perspective. And if I had not asked him those cross-examination questions, the jurors would have been led to believe a lie, which is that this is a burn surgeon. No, he's not. He's a courtroom doctor. And then they called in an expert witness on, who was the last guy they called? Yeah. Oh, boy. Yeah, so they call in this urologist, and he just seemed unhappy. Like, why am I even here? I cross-examined him and got him to admit to everything, which, defense lawyers who've tried cases against us know that every time they call a witness, we're going to advance our case through cross-examination. And the smart defense lawyers just stop calling witnesses or don't call any. Dr. Adario is a psychologist that never saw Michael and came in and spouted a bunch of bullshit, and he got thrashed. And I told the jurors in an opening statement on the damages case that any expert they call in here is going to get thrashed. That's what I told the jury. And that's what we did. Dr. Roberta Falk is a treating therapist who gave Michael psychotherapy and came in and testified that Michael has severe PTSD. He still relives this. He still cries out loud in his dreams and wakes up and re-experiences everything. And then with PTSD, and PTSD does change the brain, when you have triggers that are going to cause you to re-experience and relive the event, the PTSD is just this vicious cycle, right? And every time he touches his penis or does something, it hurts, it causes intense pain. That's a trigger that's causing him to re-experience the traumatic event.
John was alluding to this a little bit earlier, but I want to talk about the corporate reps. We always, they're sometimes interesting in 30B6s, but they're always interesting on the stand. I think people that watch us on CVN had a lot of fun watching how the corporate rep was dealt with. But John, is that were you alluding to a little bit about the corporate rep on the stand earlier?
I think the corporate representative was one of the, definitely one of the most humorous parts of the trial. And it was something that happened very spontaneously because Starbucks, the entire corporation, had taken this ridiculous position that, they couldn't deny that the cup wasn't secure, but they also were saying we're not responsible whatsoever.
Right.
So this was
our hands were off it.
Yeah. So this poor woman had to be the human being who was taking that position in a witness stand. And it was hilarious to watch.
And Nick, This is what people really want to know about, because you almost never take these depositions. It happens sometimes, but you didn't take this deposition, correct?
I hope not.
Right. So how do you be spontaneous like John's talking about when you weren't the one that took the deposition? Not all the answers are in the deposition. You end up with this person on the stand. You've got to go with your gut. You're sometimes asking questions you don't know the answer to.
What's the story? What's the human story? The deposition doesn't control what the human story is. The deposition is, these are questions asked. There's no jury there. There's no judge there. And depositions are often, taken for discovery purposes. You want to learn information. So you get facts, you get information, you may get a feel for a witness. But that is completely different than the way you present the case and present the story at trial. So I'm not limited, and no lawyer who's a real trial lawyer should limit themselves to what they're getting in the deposition. And they look at the deposition, oh, wow, that doesn't give me something. Okay, that doesn't limit you. Not at all. The courtroom is your stage, right? And the different witnesses are the actors, but you have to direct. You have to pull the truth out and weave the facts in and bring it out, live in front of the jury. So that corporate rep was a gift. The defense called her, which was a really stupid mistake, which I'd say most of the time when my opponents call any witness, it's a stupid mistake because I'm going to make my case with them. And they not only called her, the defense opened the door by asking her this question. You saw the video, right? You were the manager at the time. She's now the corporate rep and she's been, elevated within Starbucks. You watched the video, right?
Yes.
Did your employee, did the barista do anything wrong?
No.
Because the jurors have now seen what happened. And to now have a corporate representative get up there and say that she did nothing wrong. So I got up and my first question to her was, you've been with Starbucks for a while. You plan to stay with Starbucks, move up. And she goes, well, if that's God's plan. And then we got into the facts and I went up and brought this to life. And if you had the courage to actually, bring something to life in front of the jury, here it was actually going up and, taking the cups and the tray, going up there to the witness stand, not just asking her questions, but going up there and interacting with the witness and putting the cups in just the same way that the barista did. 1, right? Pushing it down. 2, pushing it down. I put the first one in. Pushed it down. I said, is that cup in right? And she couldn't help but to tell the truth. And she couldn't help but to help our case, right? She couldn't stop it because it's real. And you got a judge there and there's the defense lawyer can't stop it. I put the first cup in. I push it down. I say, is this cup in right? And she goes, Pushes it down. She goes, yes. So I put the next one in, pushed it down. Is that cup in right? Yes. She pushes it down. And then I put the third cup, just put it in that much. So it was, this much higher than the other two cups, from the two other cups. And I said, is that one in right? Is that safe? She looks at it, grabs it, pushes it down, and the jurors see it. And she goes, now it is. And then I pulled it out and I said, will you hand it to me? And I actually, pulled it out a bit, and then I handed it over to her. I said, will you take this and hand it to me? She goes, set it down there first. So I set it down. She pushed the third cup down, and she goes, now I'll hand it to you. And so I pulled it up. This went on and on in front of the jury. And so finally, I convince her to actually hand me the tray with the one cup, not secure. And she hands it over to me. I said, now, if you handed it to me this way, knowing that this is a scalding hot drink, you handed it to me like this and it spills on me, you'd be responsible, right? And she goes, nope. Unbelievable. You can't write this shit. But in trial, if you know how to try a case, the truth comes out. The truth comes out. That's the beauty of a jury trial. And it's way different than a deposition, where lawyers can say, we're taking a break, and take their witness out in the hall and woodshed them and, come back in, and all of a sudden they don't remember. In front of a jury, listen, if that barista who caused this burn came to testify, she would remember. She would remember because she'd be there in front of a jury and a judge, and it might take a bit, and she'd go, yeah, I remember. Of course she would. But in a deposition, they get away with their corporate bullshit.
Let's talk about how you look at, in California, what they call 998s or offers of settlement or demands or whatever word you're using. What was the procedural posture, and what were the offers leading up to even getting to trial before we talk about the one that everybody else is talking about?
I always give corporations, we always give insurance companies an opportunity to settle. We do. We give them a reasonable opportunity. In this case, it was $19,350,000, which I think was reasonable for a permanent injury to his penis. If we, could avoid trial, avoid the cost of expert witnesses, months and months of preparation for trial and 3 weeks in trial, right? So we gave him that opportunity. They offered $3 million. And right before trial, we had a conversation, and, the defense lawyer said, what would it take to settle? And I said, I think that if he came to me with $13.5 million, Michael might take it. And he called me up and he goes, Starbucks isn't even going to put up its self-insured, amount of money, basically the deductible, if you will. Starbucks isn't even willing to pay that. They want to go to trial. And I said, okay. So we beat him on liability. And then they called up and they said, hey, we'll offer what's called a high-low of $10 million to $20 million, which means that no matter what, if you get a verdict under 10 million, then you still get 10. If you get a verdict over 20 million, you only get 20. So they came with that proposal, and I think I took 3 seconds to say no. And they came and said, well, what will it take to settle the case? And I said, well, now we beat you on liability. We've got you, and this jury is with us, and they're going to now see what happened to Michael. So 50 million is our number. And he came back and said, well, we've only got 30 million in insurance within this first layer. Now there's a tower of insurance, so there's hundreds of millions of dollars in insurance, but he says, we're kind of stuck within this layer. Would you consider settling for 30 million? So we said, we will. If and only if Starbucks apologizes and promises to just send out a memorandum to every Starbucks in the world. And that could be an email. It doesn't cost them, $1 to send that out. Saying that from now on, when it comes to hot drinks, the lids are double checked. And when they're placed into, trays or drink holders, that you double check them to make sure they're safe, so that this doesn't happen to somebody else, or we can at least minimize, the possibility of this happening to someone else like Michael. And they were going to do it. And then someone in corporate said, no, we're not. So they offered us 20 million. We said no. and they offered us $30 million and said, but we want confidentiality. We're not willing to accept responsibility, and we're not willing to change our ways in any way, shape, or form. So we all talked about it, and we agreed that we would much rather risk getting a lower verdict to effectuate change and to protect other people. So even if the verdict was potentially going to be lower, he was willing to risk that to make sure that other people were protected, so that Starbucks would be held accountable publicly. And the jury came back with a $50 million verdict. There were 3 jurors who were crying that dissented, that did not agree with the verdict. In California, the verdict has to be 9 out of 12 people. 3 of those jurors wanted the verdict to be $125 million or more. So Starbucks dodged a bullet of justice on this one by only getting hit with a $50 million verdict. And now, because we gave them that opportunity over 2 years ago to settle for the $19.35 million, Starbucks owes over $61 million now. And they're going to have to pay our attorney's fees for refusing to admit liability.
Well, Nick, you brought up the offer policies and the fact that your client had the courage to say, I'd rather change for everybody than me be the big winner here today is absolutely awesome. And thank goodness you had a client like that.
It is, because, listen, I'm always willing to burn it all to the ground. None of this fancy shit defines me. I could care less, right? As long as I got a roof over my head, I can feed my kids and, maybe walk on the beach somewhere, and it doesn't have to be in this country. I'm happy. So I'm willing to burn it all to the ground for the right reason. But it's the client's decision. And this was Michael's decision. And Michael wanted to protect other people just as much as we did.
Do you think now this size of verdict, this type of thing, and I looked at the stock, it's hard to tell if the regular old stock market's affecting them. They're down a few percent. The average is not quite that much, but will this cause a policy change in Starbucks?
Absolutely. I guarantee you that there are hundreds of people in the world who didn't get burned this week because of this verdict, because people are double checking the safety of the hot drinks that are being handed over to people. This story has gone all over the world, and that's a good thing. And I guarantee you that if I'm a barista or you're a manager, you're gonna pull people together and say, do you see that verdict? Let's make sure that we take an extra second or two to care about our customers and make sure that what we hand over to them is safe and that we're not handing them a catastrophic, life-changing burn.
Down the last couple of questions. We're really talking, the analogy is always David and Goliath. What general advice would you give to attorneys that are going up against these monster corporations? And when you think about it, Starbucks, I always thought had a cool story, right? An employee bought Starbucks from the person who started it, right? And that CEO led until about 2000. Their current CEO, who is the CEO that's going to be looked at for this, within the first 4 months was paid $96 million. This verdict doesn't even touch almost half of what their current CEO made in the first 4 months of his employment when he transitioned to the CEO.
What would his penis be worth if it was ruined because somebody negligently destroyed it?
More than $96 million.
Probably, yeah.
But this David and Goliath thing, do you have actually advice, or is it just you just go? You just got to keep fighting. Listen, when you get in front of a jury, that's the one place where a normal, everyday person can stand equally against a corporation. And if there's a trial lawyer who's capable and willing, that's all you need. And the lawyers out there just need to have the courage to keep fighting. And sometimes we get beat. We just got to keep getting back up again.
Thanks for listening to Brutal Honesty. If you enjoyed this episode, please share it with others, post about it on social media, or leave a review on Apple Podcasts. To catch all the latest from Nick, you can follow him on Instagram and YouTube at Jury Trial Lawyer, and sign up for events at trialbyhuman.com.